This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Usually, I have to cut down and digest opinions of courts because they're lengthy. Today, we're speaking about a court opinion where it simply states the facts in the law. And it's a case where if a lawyer does nothing, he or she will find that she will lose automatically, and why failure to respond to a motion for summary judgment is fatal to a lawsuit. And every lawyer should know that if you fail to respond promptly to a motion for summary judgment, a judgment will come against your client, and you should be making a report to your legal malpractice insurance company. In a case called Craig Marcello et al. Versus Allied Trust Insurance Company, the United States District Court for the Eastern District of Louisiana on January 17, 2025, by Barry W. Ashe, United States District Court, held that a motion for summary judgment filed by defendant Allied Trust Insurance Company was set for submission on January 23, 2025. Local Rule 7.5 of the United States District Court for the Eastern District of Louisiana required that a memorandum in opposition to a motion be filed no later than 8 days before the notice submission date, making the deadline in this instance January 15, 2025. Plaintiffs Craig and Virginia Marcello, who were represented by counsel, did not file an opposition to the motion. Judge Ashe concluded that because the motion was unopposed and appeared to have merit, ordered that Allied Trust's motion for summary judgment was granted, and plaintiffs' claims against it were dismissed with prejudice. In my opinion, one of the first things a young lawyer learns is to calendar dates for filing opposition to a motion filed by the other side of a lawsuit. This case was dismissed because the lawyers for the plaintiffs did not file an opposition to the insurer's motion for summary judgment. Only two reasons exist for such a failure. One, there existed no facts or law that could be used to oppose the motion. Or two, counsel failed in his or her duty to represent the plaintiffs. If the first was the reason, the case is over. If the second, the plaintiffs are not without a remedy, since they can sue and recover from their lawyers, who should be reporting a potential claim immediately to their malpractice insurers. This video was adapted from my blog, Zalma on Insurance, which is available free to anyone who clicks on the URL zalma.com/blog. You can subscribe to the blog, and if you do, you'll receive notice of every blog posting, usually 5 or 6 a week. You'll also gain access to the more than 4,950 blog postings. Please tell your friends and colleagues about the blog and these videos so that they too can subscribe. And if you're interested in further detail about insurance, insurance claims, insurance law, and insurance fraud, please consider subscribing for a very small fee to my Substack publications. Thank you for your attention.